Welcome to Rebel Chaser. My name is Gail, and I've got a video for you from Judge Thornton in Richland County. He is presiding over a divorce and custody trial. So I'll let you guys watch.
Richland County District Court is now in session this September 26, 2025. The time is now 9:12 a.m. My name is Nick Thornton. I'm a district court judge for the Southeast Judicial District, which includes Richland County. We're in Richland County's large courtroom. The door is unlocked and open. The building is unlocked and open. We're live streaming today's event on the Southeast Judicial District's live stream YouTube channel. As such, they're open and public proceedings. In this case, this is a divorce case. There has been a motion for interim order. There were a number of declarations filed in support of the motion. That hearing was originally scheduled, I believe, for August 18. After some discovery issues and some service issues, this hearing was continued to today's date. Have those issues been resolved, Mr. Green?
Pardon?
Have those issues been resolved?
Yeah, I think I agreed that we would let Mr. Johnson's declarations come in. I don't know if he's fixed the thing on the bottom, but I'm fine with it.
All right.
But the other objections remain.
All right, we're going to take those up. Mr. Johnson, is that accurate?
I believe so, Your Honor.
All right. So in this case, it's Anderson v. Anderson, file 39-2025 DM36. Brooke Anderson is present together with her attorney, Jonathan Green. Eric Anderson is present with his attorney, Samuel Johnson. So the parties had talked about mediation that was going to occur before today's hearing. Did that resolve anything?
No,
From
Your
your
Honor.
perspective? No? All right. So in support of defendant's motion for interim order, financial statement was filed by Eric Anderson. Eric Anderson's declaration, record index 29. Vivian Anderson's declaration, record index 30. Nicole Anderson's declaration, record index 31. Matthew Anderson's declaration, record index 32. James Johnson's declaration, record index 33. Abraham Bingham's declaration, record index 34. Those were all filed initially back on July 28. Brooke Anderson filed declaration in response, record index 39. Financial statement, record index 40. Both parties have filed notice of intent to cross-examine. Both parties have filed numerous exhibits. Eric Anderson filed a declaration in support of that emergency continuance, and I believe there were some factual assertions in that declaration. Brooke Anderson filed a number of declarations as well. Nicholas Williamson, Heather Retzer, Miranda Ridley, that's 101, 102, 103. Filed objections with respect to Eric Anderson, Vivian Anderson, Matthew Anderson, Nicole Anderson, Abraham Bingham, James Johnson. Those objections are noted in record index 105 through 110. Further objections were lodged to video exhibits 39 through 100, record index 113. There were responses and further objections, record index 114. Eric Anderson filed a declaration in response to the counter motion, record index 138. In response to the declaration of Miranda Ridley, record index 142. And in response to Heather Retzer's declaration 143. Declaration of Jacob Stanley Upham 144. Brian Gwynn, record index 145. Vivian Anderson filed a supplemental declaration. And Cornelius Holt filed a declaration 147. So it's 146 and 147. Plaintiff filed a financial declaration 149. All right. So those are the declarations that have been filed by both parties. Mr. Green, are all of your witnesses present that have filed declarations?
Yeah. Yes, Your Honor.
Mr. Johnson, are all of your witnesses who filed declarations present and available for cross-examination?
No, Your Honor.
Who is not present?
Abraham Bingham, who was sick today, and Cornelius Holt. His grandma passed away in Missouri, couldn't make it. And
I think that's the rest of them are.
yeah, the rest are either on Zoom or in the court.
The rest are present.
Correct.
All right. So, low-hanging fruit, there's been a demand for cross-examination filed by both parties. If Mr. Bingham and Mr. Holt are unavailable for cross-examination, the court is not going to receive those exhibits, those declarations. Next issue is the objections. In light of the numerous objections filed by both parties, I'll start with Mr. Green's objections because his were first in time. And then I will move to Mr. Johnson's objections and we'll take them up one by one. Mr. Green, go ahead and argue your objections that remain.
Your Honor, with respect to the hearsay objections and the objections to the declaration, I brought them forward to the court just to note how many or how much hearsay is in there. And now there's even more with these new declarations filed. I think the court, this is the bench trials. I know the court knows what hearsay is. However, I also know that I need to create a record as well, and that's why they're filed. And so I guess I'm just drawing the court's attention to the hearsay throughout those declarations, including the newer declarations. I didn't submit hearsay objections in the newer declarations, but I didn't do so because I planned on doing it this morning here in front of the court and just have the court acknowledge that there's probably some hearsay in there. And to be honest, Your Honor, there's hearsay in some of mine too. It's just the nature of the beast sometimes when you have people writing their own things that some hearsay is going to be put in there. And I could have went through and cleaned it up, but then I felt like I would be manipulating their statements. And so with respect to my hearsay objections, Your Honor, I would just request the court give the hearsay the weight it deserves, which is none. And that goes for mine too, I guess. If there's hearsay in mine, I think this court should throw that out. But I think there's far less in the declarations that I've submitted on behalf of my client than there are in the declarations that were been submitted on behalf of RX.
So Mr. Green, are you asking me to go through and address each hearsay objection and give you a specific ruling on it?
No, I'm actually asking you to do the opposite. You don't need to issue a ruling. I think the point of this is that I think this court knows what hearsay is and it can identify the hearsay as it goes through it, and it does not need to issue. Basically, it's a standing objection to all hearsay, and I'm not looking for a ruling on any one particular statement. I just want the court to note that I noticed there was a lot of hearsay in there, and that the court should be cognizant of that and give it the weight that it's deserved.
How am I to address hearsay exceptions if I don't rule on them? I mean, I certainly can do that, but both parties are entitled to an argument on it. If you lodge an objection, Mr. Johnson is entitled to say that he thinks it falls within a hearsay exception.
And if Mr. Johnson wants to go through each one of those, he can. I don't think I don't need to.
All right. Do you have any other objections to the declarations that have been filed?
I'm not worried about that anymore. No, Your Honor.
Mr. Johnson, your response to Mr. Green's proposed plan to simply give hearsay the weight it deserves and to have the blanket standing objection to hearsay in declarations.
I agree, Your Honor. I would think the court was going to do it by as it came up or whatever. Generally speaking, people don't file objections to hearsay prior to a court ruling, but since he did so, I agree with Mr. Green. You just give it the weight that it deserves.
All right, with both parties essentially consenting to that process and understanding that I certainly will give the evidence in the declarations the weight it deserves based on the court's credibility determinations and the rules of evidence. But both parties appear to be foregoing their opportunity to respond to the objections or what the court believes is hearsay. And with both parties agreeing to that procedure in light of the voluminous declarations here and the voluminous amount of potentially objectionable material in both parties' declarations, I'm fine with it if you're fine with it. That's what I will do. I'll give those objections. I'll take them all under advisement. I'll consider them at the time that I issue my ruling. I don't intend, in light of the number of declarations that have been filed today, to issue a ruling from the bench. I will take this under advisement at the conclusion of today's hearing and issue a written decision shortly. And I will explain if I find something is important to one of the parties' arguments and also subject to potential hearsay, I will note that in my findings. So the parties will have a record in my written findings explaining what I find objectionable based on parties' standing objections to hearsay, frankly, in all of the declarations filed. Is that acceptable to you, Mr. Green?
It is, Your Honor.
Is that acceptable to you, Mr. Johnson?
Yes, Your Honor.
All right. So having disposed of that issues, Mr. Johnson, do you have any objections that are not a standing objection to hearsay that you would like the court to address right now?
Yes, Your Honor. I would like to address the objections that I set forth in my objections dated August 18th, 2025. Essentially, the plaintiff submitted approximately, I believe, 60 videos, many of which were just snippets of recordings. And for the court's information, I have requested this information in my discovery. It has not been received. It has not been submitted to me. And so I would ask, Your Honor, under Rules of Evidence, Rule 1002, first of all, we never got the original recording in regard to any of these. We got snippets of essentially what they wanted the court to see, not the entire video itself. The plaintiff, subsequent to the commencement of the divorce, installed approximately 11 cameras running 24/7 for at least 128 days, thousands of hours of footage. And we were only provided trimmed recordings, the longest of which was 11 seconds. The shortest of which is 11 seconds, or I'm sorry, the longest of which was 11 minutes, and most are only about 2 or 3 minutes long. It's basically about 10% of the interactions that would have taken place in the home. And I kind of went through my objections, essentially a number of things that they did, the reordering that they did, essentially rearranging the sequence of the video clips and creating a fabricated timeline of events or manipulating the perceived cause and effect relationship, especially in exhibits 42, 44, 51, 58, 81, 82, 97, 98, 99, all taken on the same day on February 24th. They omitted some things. They removed significant segments from a video to present a different narrative than the complete footage. For examples, in exhibits 41, 50, 79, and 80. They did some trimming. They knowingly and intentionally shortened all the clips at either end of the clip to alter the meaning of the defendant's recorded statements or actions and misrepresenting the true nature of the event. For example, exhibit 75 only shows that Arik was on his phone for exactly 10 seconds when HER falls behind the couch. Because it is shortened, it doesn't accurately reflect exactly how long he was on the phone. We can only know for certain that he was on the phone for 10 seconds, which is by no means a long or neglected period of time. They've got concealment, Your Honor. For example, exhibits 41, 64, 66 highlight that the plaintiff has put cameras in areas where the audio would be distorted or concealed by ambient noise, like right next to the TV. They're not a true and accurate and clear representation of said interactions. And then we have a lack of validity and relevance. Since the parties decided to divorce, basically the plaintiff has attempted to utilize some of the videos in the harassment restraining order proceedings, which was dismissed. Further allegations in 2 CPS reports, both of which were unfounded. One was terminated in progress, one was unfounded. So we believe, Your Honor, that this was a deliberate and intentional attempt based upon the plaintiff's past experience, being that this is her 4th divorce, to place the defendant in a light, which he is not. And we know that they mislabeled so many of the video exhibits are just basically false misrepresentations.
So, Mr. Johnson,
The court.
do you have the thousands of hours of video?
I don't have, all I have is what they submitted. I do not have. We requested it. It was not provided.
So have you filed a motion to compel?
I have not, Your Honor, because the discovery was actually due 2 days ago. And so I haven't had a chance to file a motion to compel. I have sent them an email requesting the discovery, and it wasn't responded to.
So this appears to be home security camera footage.
It is, Your Honor. They had other cameras that were in the house collectively together prior to the divorce, and then subsequent to the divorce, she placed at least 10, if not 11 cameras throughout the household, unbeknownst to my client's knowledge. And I guess our position, Judge, is that we haven't had an opportunity to see all the video coverage in that regard.
So if I compelled discovery and said, you get the video by tomorrow, and you get 1,000 hours of video, when are you expecting the hearing to happen? Or are you suggesting that I should review 1,000 hours of video?
No, Your Honor, you would certainly not. But I would at least have an opportunity to review all the video, and then I could narrow it down into so that the judge.
If you don't have the video, how do you know that the video has been manipulated, cut, clipped, or created a false narrative?
Well, first of all, if you have a video for 24/7, and now you're taking a 10-second to 2-minute or 11-minute, my client knows what happened.
From his perspective, right?
Correct. And so we would like to be able to show that perspective.
So this is a discovery issue, not a best evidence issue.
Well, I agree that it's both a discovery and a best evidence. And I mean, with
The motion was brought by you, though. So why did you bring the motion before you had the discovery?
my objection was brought.
No, the motion for an interim order was brought before you had the discovery.
Well, first of all, the motion for the interim order was brought before we knew there was cameras in the house. Okay, so that motion that we made.
But Mr. Johnson, you just said that there was cameras in the house before the parties decided to get a divorce, and your client knew that.
No. They collectively agreed to have various cameras in the house.
So he would know.
We're talking about 11 other cameras, the videos of those which were hidden throughout the household in different areas, picked up some, but not all of the video footage of those cameras that they knew were there.
But you have access to cameras that would show the full story, right?
No, Judge. So
So you're saying that there's cameras that the parties agreed to in the home that have been there the entire time. And then you're saying that Miss Anderson hid another 11 cameras. So theoretically, there would be cameras that would be the ones the parties agreed to, plus another 11 that only she had access to.
right.
And what they filed is and I haven't watched the videos, so I don't know what's in them.
Your Honor,
So what you're
can I interrupt just briefly? It might save you guys both time. I don't plan on introducing any videos today.
No.
So does that help?
Have they been filed?
introducing any videos today?
No.
Well, that takes care of our issue today.
So the objection is moot and it's denied as such. Any other objections we need to address, Mr. Johnson?
I'm sorry, I didn't hear that.
Any other objections, Mr. Johnson?
No, Your Honor.
All right. Any other pre-hearing issues we need to address from your perspective, Mr. Green?
No, Your Honor.
Any other pre-hearing issues we need to address, Mr. Johnson?
No, Your Honor.
All right. Mr. Johnson, it is your it's your motion. So you can tender your declarations and your witnesses that are present for cross-examination.
Thank you, Your Honor. Your Honor, is it customary for the court to hear an opening argument, or in these particular cases?
If you want to give me an opening argument, go ahead.
All right, thank you, Your Honor. Your Honor, this has been a very tumultuous dissolution of a marriage. But I wanted to bring to the forefront to the court why we are here today, okay? And I want to give my client's perspective with respect to this matter and some insight before we proceed today so that it understands essentially where our position is at. So from the very beginning, Your Honor, the plaintiff admitted in her own declaration that Art, the father of Harper, was a stay-at-home dad. In their complaint, Your Honor, and in their reply, and also in their proposed order, there was nothing in regard to my client's mental illness. There was nothing regarding verbal abuse, mental issues, or anything of the like. Now, after the divorce has commenced, now she alleges a plethora of things, including verbal abuse, mental illness, drinking, gambling. None of that was in any of those documents. And in fact, in their proposed order, they indicate that my client can have unfettered, unsupervised parenting time on an every other weekend basis. And I say that, Judge, because most of their declarations and their evidence submitted to the court was indicating that my client had all these issues that should be with the child, and time should be limited and all kinds of things. But the fact of the matter is that even in their own documents, they indicate my client can have unfettered parenting time, and their proposal is every other weekend. So with that, obviously, if my client can have unfettered parenting time every other weekend, he can have the child on a full-time basis. But what's really disturbing, Judge, is what has happened since the commencement of the divorce. And I outlined that more specifically in our supplemental, or his last declaration submitted to the court. But on the eve of my client asking Brooke for a divorce, and after she stated to him that you're going to lose everything, which is stated in his declaration, she began a series and a pattern of attempting to absolutely destroy not only Arik, but completely acted in defiance of what was in the best interest of this child. For example, Judge, literally installing 11 hidden cameras in the house.
How does that affect the child's best interest?
I'll get to that. I'll get to that, Judge. In addition, Judge, the child had been sleeping in its own room, in its own bed, and had become independent for a significant period of time up until the day he asked for that divorce. On that day is the day that she decided that she's going to kick my client out of that bedroom. And they had a lock on the door, but they only used it for their privacy. But she was going to use that lock, and she was going to bring the minor child into the bedroom and alienate the minor child from my client. In addition to that, Judge, not only did she do that, but she took her other child, at that point was 14, now 15, took her out of her bedroom and locked the three of them in their bedroom every single night, got home from work, took the child and locked this child, refusing to allow the child to maintain or sustain the independence that she had already achieved. So here every night, Harper's sleeping with mom. Her 14-year-old daughter, Elizabeth, is sleeping on a mattress in their room. Locking the door, refused my client admission into that room. Then she did 2 CPS complaints, Judge. One was terminated in progress, one was unfounded. Then, Your Honor, she tried to get a harassment restraining order, which was denied. She attempted to change the daycare, Judge, from 1 day to 4 days. She trespassed their friends, Abraham and Nikki Bingham, from the home. She tried to press charges on their son, the Bingham son, for trying to deliver groceries into the home. She refused to allow Arik to participate in Elizabeth's day-to-day activities. That's her 14-year-old child, even though he had been doing that for the duration. She's threatened contempt of court. She took videos and photographs in church, forcing the pastor to literally talk to her. Now she refuses to go to that church. She left with the child to Michigan for a week. And even though he knew that at some point in time that she was going to be going to Michigan, he didn't know exactly, but left in the middle of the night, took the child to Michigan for an entire week. He cut off Arik from the internet, cut him off from the cell phone. She takes the minor child out of the house after coming home from work and returns at random hours, sometimes not at all. But I think one of the worst things that she has done, Judge, is this. Remember, my client is a stay-at-home dad, and that was his role and had been his role. Essentially, by her own admission since April of 2024. Now remember, my client maintains it was before that, but she admits in her declaration from April 2024. But on what she did on that day when he asked for the divorces began a pattern of literally locking the child into the room, refusing to provide my client with the child before she left for work in the morning. The child was sleeping till 8 a.m., now getting up at 6 a.m., now being forced out of the house at 6:30 a.m., walking right by my client who was sitting there saying, I'd like to take care of the child today, bolting out of the house, bringing the child to the daycare provider, forcing Arik to go to the daycare provider to pick up the child within minutes. Got to the point where they were meeting in the driveway of the daycare provider where he would take the child. Finally, the daycare provider had had enough of this and fired him, essentially. And then she started taking the child, for one day at least, to her father's residence, her mom and stepfather. Well, finally, in the last 20 days or so, she has discontinued those activities, and my client has been able to have the child on a daily basis. But this is the extent to which the plaintiff's actions have gone to try and obtain or alienate the minor child from my client, knowing and admitting that he was a stay-at-home father by her admissions from April 2024 to the present. These are her actions. And, Your Honor, these actions are clearly not in the best interest of the child. And I wanted to just bring that to the court's attention because that essentially is why we are here today, as a result of these continued and repeated actions which are not in the best interest of the children. And with that, Your Honor, I close.
Mr. Green, any opening statement?
I'll be more brief than Mr. Johnson. That read more like an argument than an opening statement. But what I will talk about is the evidence that will completely contradict what Mr. Johnson has just said. Arik is not a stay-at-home dad. Arik is a disabled veteran who stays at home and cannot take care of a child because of his mental health issues. Arik does not work because he's incapable of working because of his mental health issues. With respect to my client locking the child into the bedroom, Your Honor, you're going to see a text message from Arik that reads, I am unavailable from 7 p.m. to 7 a.m. If you need anything, for Harper, must be an emergency to reach out to me. It's going to read something like that. And there's a reason for that, Your Honor, because when my client gets home from work, she's the one responsible for caring for that child. And at least he's acknowledged that Harper has been staying with my client overnight. That's the one thing that's been honest that came out of the entire declaration. And that's not hearsay. The reality of it is, Your Honor, is that despite not being able to maintain employment, despite staying at home, despite all of that, he's elected not to raise Harper or to raise her in a limited capacity. And it's probably for the best given his mental health state. Attorney Johnson indicated in his opening argument that we've never mentioned this mental health in our complaint. We didn't bring it up in the interim relief when we said that he could have every other weekend. Your Honor, Mr. Anderson is capable of taking care of the child for a couple of days, and that's it. You're going to hear that from my client. That's it. The elephant in the room, and the one person that's not here, is the daycare provider who can say that the child's been going to daycare. There's an exhibit A that was supplied by ARC that's hearsay, and it wasn't even what was provided by the daycare provider, but she will be testing at the evidentiary hearing in this case. In fact, much more evidence will be coming out at the evidentiary hearing in this case. The reality of it is, Your Honor, my client has been taking care of this child for consistency and continuity during the pendency of this divorce. It is in the child's best interest that she maintains the same parental control that she's had her entire life. And that's that Brooke has been the one caring for her. It's interesting when this court compares Mr. Anderson's first declaration to his second declaration, how much new information has come to light from Mr. Anderson. Suddenly, all of these new things exist. Why wasn't it in his first declaration? I'll tell you why it wasn't in there. Because most of what he says is not true. If it was true, if it was as egregious as he's made it out in his second declaration, Your Honor, then why didn't he say it in the first one? Mr. Anderson's had two opportunities now to come at my client. My client's only had one to go after him. And the tone of his second one is far more aggressive than the tone of his first one. I would submit that's because when we laid out the truth, it struck a nerve. Lastly, Your Honor, in terms of the marital home, my client's asking for that marital home because she's got two kids she needs to raise. The one that she's adopted with Arik, who's subject of this divorce, and her own child. For continuity's sake, their child should remain in the home with my client. And quite frankly, her own child would benefit from that as well. I think after this court has an opportunity to hear from my client today, despite the fact that Arik has used the phrase narcissist or the word narcissist throughout the entirety of both declarations, in particular the second one, you'll see my client is not a narcissist. That phrase I've learned over the course of my years of practice, Your Honor, comes up when there's nothing else that someone can say about an individual. With that, Your Honor, I rest.
All right. So under Rule 615 of the North Dakota Rules of Evidence, I am going to sequester witnesses that are going to testify. Those that are appearing remotely will be put in a waiting room. That does not apply to the parties, but all other witnesses that have submitted declarations. I will ask Mr. Johnson to tender his witnesses as the party who moved first, subject to Mr. Green's cross-examination. Go ahead, Mr. Johnson.
Thank you. So you're asking for all of the witnesses here to leave, right?
All of the witnesses except Brooke and Mark need to leave. And we'll put other witnesses appearing remotely in a waiting room.
That's all you guys do.
Anyone who's not a witness who filed the declaration can stay in the courtroom.
I will. If you've submitted a declaration, you have to go to the hallway.
Okay, so the only bad thing about this is they never came back on. They did this part, they kicked all the witnesses out, and then they never showed any more. This was all they showed. So I don't know if they didn't do any more and they were holding off until, Monday or Tuesday till they could watch some of these videos. Although it sounded like they weren't going to include any videos, but I don't know. Or they just decided not to stream it. So I'm hoping that it will come back on Monday and we'll be able to watch it, because if this mom did the things that Dad's attorney is accusing her of, wow. She is quite the conniving, manipulative human being. And since it's her fourth time at a divorce. It doesn't say much for her track record, but she probably gained a little, she learned how to use things to harm the other party, is all I'm going to say. So hopefully it'll be on Monday. I will look on Tuesday. If it's not on Monday, I will keep an eye out to see. Hopefully they come back on and show us the trial. I really want to see it. So thank you guys so much for watching, and I'll see you another time.